Swayam Prabha. Digital India. Educated India.
Hello viewers, I am Dr. Saurabh Rana, Faculty of Law, University of Delhi. I, along with Professor Dr. Vageshwari Deshwal, shall be discussing procedural criminal law, that is now BNSS 2023, which was earlier known as CRPC 1973. This is session 3, and in this session, we shall be discussing power of court and powers of police officers, senior police officers, in fact. Now, before we see power of court in chapter 3, let us first see the classes of criminal court. As we are dealing with BNSS and it provides criminal procedure, it provides procedure to be followed in criminal court, precisely to say. So, let us first see as to what are the classes of criminal courts in a state. Now, for that, let us look at chapter 2. Section 6 of chapter 2 says, besides the High Court, that means that High Court also has criminal jurisdiction. Of course, apart from other jurisdictions that it possesses. It says, besides the High Courts, there shall be in every state the following classes of criminal courts. Number 1, Court of Session. Number 2, JMIC, that is Judicial Magistrate First Class. It is in practice called JMIC. This I is first, IC, class. Judicial Magistrate of second class. So that may be written as JMSC, second class, or maybe like this. Then Executive Magistrates, SDM, DM, as we know. So they all are criminal courts. High courts in a state, session, judicial magistrate first class, judicial magistrate second class, executive magistrate. Now, section 8 says that the state government in a state for every session division. Now, what is a sessions division? Session division, section 7 says that every session division shall be one or more than one districts. Now, you see, the idea of district is an administrative idea. You find a DM as the head of every district. SSP would be there, every district. So, district is an administrative idea. It's an executive idea. On executive side, that will find district as the unit. On judicial side, we have sessions as the basic unit, and the state shall be divided in sessions divisions. And for every sessions division, as I said, there would be one or more than one district. For every such sessions division, there shall be one sessions judge and as many additional sessions judges as deemed fit by the state government. Section 8 further says that every court of session shall be presided over by a sessions judge to be appointed by High Court and as many additional sessions judges in a court of session. Generally, the senior, so they would be of the same cadre, sessions judge would be the senior most among them. And section 8(7) says that the sessions judge, who would be the administrative head of the sessions division on administrative side, on judicial side also, of course, he would be working. On administrative side, he would be distributing the business among additional sessions judges. So that was about the courts of session. Now section 9 says that in every district, so this again, as I said, district is an administrative idea. Section 9 says that for every district there shall be established as many courts of judicial magistrate of first class and of the second class as the state government after consultation with High Court may deem fit. Then it says, section 10, that in every district the High Court shall appoint a judicial magistrate of first class to be the chief judicial magistrate. Now, as I said earlier, out of the cadre of judges cadre, the senior most would be the session judge of that session division, and the rest of them would be like additional session judges. Here in the same pattern, out of the JMICs, GM first class, which are there in a district, the senior most would be appointed as CJM, and the rest of them would be working as judicial magistrate first class. Again, CJM would be, of course, working on judicial side as well as on administrative side. He would distribute the business among the judicial magistrate first class and the judicial magistrates second class. In that parlance, section 13 says that every chief judicial magistrate shall be subordinate to the sessions judge, and every other judicial magistrate shall, subject to the general control of sessions judge, he shall be subordinate to the chief judicial magistrate. So the hierarchy would be like the judicial magistrate first class at the bottom, then their administrative senior would be the CJM who would distribute the work among them, and above CJM, sessions judge would be there. Then section 13(2) says that CJM, of course, I said that CJM would be distributing business among the judicial magistrates subordinate to them. So that's how the courts are divided. In High Court, as in criminal courts are divided, are different categories of criminal courts. As in High Court sitting at the top, then there is a court of session. Every session division there is a court of session. In court of session, sessions judge sitting at the top, and there are other additional session judges. And the third rung, the lowest rung, would be the level of judicial magistrate first class and then second class. They are, CJM would be at the top of this level and would be the administrative head of all judicial magistrates in a district. Judicial magistrates are appointed on district basis. Sessions judge and additional sessions judges are appointed on session division basis. A session division may contain one or more than one districts, as I said. Now let us see executive magistrate. Now they are also shown as court, as criminal courts in section 6. Many of us would not be comfortable with the idea of an executive magistrate being a criminal court. So a SDM or a DM, discharging function as a criminal court would not be known to many of us. Now but then it has been given here that executive magistrate is also class of criminal courts. So let us first understand the idea of a criminal court. Now section 2A of Bharatiya Sakshya Adhiniyam says that a court includes all judges and magistrates, may include executive magistrate also, and all persons who are legally authorized to take evidence except arbitrators. Now if we see executive magistrates in this parlance, if you look at section 135, chapter 9 BNSS 2023, we would see that the executive magistrate may also record evidence, may also take evidence. As per that definition, they qualify to be a court. A court being a criminal court, the idea associated with a court being a criminal court in contradistinction with a civil court may be explained as that the criminal court would be issuing compulsive processes, warrants to secure presence of accused or such persons before them. That such court would be committing people behind bars, sending them to prisons. Now, if you look at section 132 BNSS 2023, executive magistrate would also be issuing warrants for persons' presence before them. And also section 141 chapter 9 show us that executive magistrate may be sending people to prisons if they do not furnish the bonds for keeping peace and good behavior. So, if you look at chapter 9 is dedicated to keeping peace and good behavior, that we will discuss later. Now, in that chapter, executive magistrates would be holding proceedings, and as a result of that, people who are found to be notorious, they would be asked to furnish bonds to the court, and if they do not furnish that bond to keep peace or good behavior for a given period of time, then in that case, in default of their depositing the bonds, they may be sent behind bars by the executive magistrate. So, we see executive magistrate is not only a court in that sense, because it takes evidence, it records evidence, as I said under section 135 BNSS chapter 9, it is a criminal court because the symptoms of a criminal court is found therein, as in it would issue compulsory process, section 132, it may send people behind bar, section 141, as I said. In fact, executive magistrate has been described as a court. If you read section 131, it mentions them as a court. The difference between executive magistrate as a criminal court and a judicial magistrate as a criminal court, and of course these judicial courts, court of session and high court on one hand, executive magistrate on the other hand, may be understood if we look at section 22 and 23. The distinction would be clear even otherwise. If you look at section 22 and 23 and compare it with section 6, section 22-23 mentions about the sentence which the High Court can pass, sessions and additional sessions judge can pass, JMIC, Judicial Magistrate First Class can pass, Judicial Magistrate Second Class can pass. It nowhere mentions Executive Magistrate. That means Executive Magistrate, SDM or DM cannot pass sentence in that sense. But Executive Magistrate has been mentioned in the category of criminal cases. The difference is evident. You see, the idea of an executive court as a criminal court makes sense only for keeping law and order situation. That on administrative side, that the executive magistrate would be exercising the functions of a criminal court. They would not be trying people for having committed the offense. Trying people, punishing them for commission of offense, for commission of crime, is exclusive domain of judicial courts. And that's why there is no mention of executive magistrates in section 22 and 23, which are dedicated to the sentencing powers of judicial courts only. So, that is the idea, and that is how we can understand the executive magistrate as a criminal court and executive magistrate in contradistinction to judicial magistrates or the judicial side of other officers. Now, after the classes of criminal court, we would see the triability of offences by different criminal courts. And if we look at section 21, again, as executive magistrate is absent in section 22 and section 23, And as I discussed that it is because of the reason that executive magistrate cannot pass sentence, because sentence is to be passed after conviction. Conviction is to be done after trial, and executive magistrate cannot try people for commission of offence. Trial is exclusively, in that parlance, is meant for finding whether a particular crime has been committed by a particular person, that is the accused. That is after commission of crime. So that cannot be done by executive magistrate, as I said earlier. In the same spirit, the heading of section 21, which says courts by which offences are triable, the executive magistrate is absent here again. Section 21. It says any offence under Bharatiya Nyaya Sanhita 2023, it is like earlier called IPC 1860. It says any offence under BNS 2023 may be tried by, and you see the executive magistrate is not there, by the High Court, the Court of Session, or any other court by which such offence is shown in the first schedule to be triable. First schedule appended to BNSS 2023. Those of us who may be knowing this thing, I mean, which have some connection with the judicial functions and all, they may be practicing, would know that high courts would not try a case. Try means that a particular court is trying a criminal case in the first instance. That is, it is the first court that is taking up the case. Now, earlier, there were 3 presidency towns, Bombay, Madras and Calcutta, wherein High Court were having original criminal jurisdictions. Now, reference to the High Court has not been omitted, but has been retained because of the extremely rare, extraordinary situation. Even High Court may exercise original criminal jurisdiction and may try the case. So, ordinary cases, it would not try the offence as a first court, but then theoretically it is possible. And in the same spirit, if we see section 447 BNSS, that section also foresees a possibility that a high court may take up a case from any court subordinate to it in the state and may try that case. Then it says that the court of session may try any offence, and then it says any other court. So, you see, the court of session trying any offence is also possible. Then it says any other court. So, that means judicial magistrate court, first class or second class. Judicial magistrate courts by which such offence is shown in the first schedule to be triable. Now, for that we have to, so for the triability of judicial magistrate, we have to look at first schedule, and when you look at the first schedule appended to BNSS 2023, you will be looking at some columns wherein every section in BNS 2023 would be shown as triable. So, as per shown in the schedule, the judicial magistrates would be taking up the case and trying them. That schedule also shows court of session for certain cases only. Now, theoretically again, court of session may try any offence, but then when we look at the first schedule, some of the offences have been reserved for tried by judicial magistrate and some of them are shown as triable by court of session. The theoretical possibility that the court of session may try any offence would be of much use, say for example, in a case where suppose there are 4 sections. One of them is shown as session tribal in the schedule. 3 of them are shown to be magistrate tribal in the schedule. Now, because one of them is session tribal, it will go to the court of session. The entire case comprising of the 4 sections would naturally go to the court of session. I mean, one case cannot be tried at 2 courts for different sections for practical convenience. Now, this provision that says that court of session may try any offence under Bharatiya Nyaya Sanhita would make it possible for the court of session to not only try this offence, which is session tribal, but also to try these 3 offences which are shown to be magistrate tribal in the schedule. So, that is the idea, that the court of session can theoretically try any offence under Bharatiya Nyaya Sanhita. Judicial magistrate would be trying only such offences as it is shown in the first schedule, and they may not try other offences, but that is not the case with the court of session. It may try any offence, and the practical utility we have seen in this case. Then it further says, provided that any offence under section 64, section 65, section 66, section 67, 8, 9, 70, 71 of BNS 2023 shall be tried as far as possible, practicable, by a court presiding over by a woman. If we see these offences in BNS, we come to know that these are offences of sexual nature. So, offences of sexual nature would be, as far as practicable, tried by a court which is presided over by a woman. Section 21B says that any offence under any other law. 24(1) was for offences under BNS 2023, 21A. 21B is for offences under any other law, and it says that they may be tried by any court which is mentioned in this behalf by such law. So, that law itself would be providing the court, as say for example in SC/ST Act, it provides a separate court which is called SC/ST court that would be trying the case, or suppose PMLA Act would be providing a separate court by which the PMLA cases would be tried. So, any offence under other laws other than BNS 2023 would be tried by the courts which are mentioned by those particular laws. And then it says, when no court is so mentioned, so when the special law does not mention a particular court which would be trying them, then those offences may be tried by the High Court or any other court by which such offence is shown in the first schedule to be triable. Through its second part, that is the second part of first schedule appended to BNSS 2023. This second part you may see at the end of the first schedule appended to BNSS 2023. Now, let us see the sentences which the criminal courts may pass. And when I say criminal court and sentence, again the idea would be of the High Court, Court of Session, Court of Magistrate First Class, Judicial Magistrate first class, Court of Judicial Magistrate second class, and as I discussed earlier, Executive Magistrate would be absent here from section 22 and 23. Executive Magistrate was also absent from section 21. As I said, their function does not include trying people, convicting them, and on the basis of that conviction sending them behind bars as punishment. Now, if you look at particular sections, section 24 BNSS 2023 says that the court of a judicial magistrate may award such term of imprisonment. Now, if we look at section 22, it provides the sentences which may be passed by the High Court or the Court of Session. And it says 22(1) that a High Court may pass any sentence authorized by law. Now, how many types of sentence that are permissible after conviction to be provided by a judicial court? We have to look at section 4 BNS, that is earlier IPC. Section 4 says there may be 5 types of sentences that may be passed by a criminal court. And of course, when I say sentence, it is after conviction. Conviction means after trial, and trial is basically a judicial function. Trial cannot be done by an executive magistrate. So, 5 types of sentences are capital punishment. Capital punishment means sentence of death. 2 is life imprisonment. Third, imprisonment, which has been further divided in simple imprisonment and rigorous imprisonment. Fourth is fine. Then forfeiture, and then community service. Community service had not been there in the old IPC, but now it has been added in BNSS 2023. We would see what community service is. So, these are some sentences that may be passed by a judicial court after trial and conviction of an accused. High Court may pass any of them. Court of Session, section 22(2) says a sessions judge or additional sessions judge may pass any sentence. So, first thing you must notice here is that sessions judge and additional session judge have been kept at par for competence of sentence purpose. Though sessions judge would be the senior most among the additional sessions judges in a sessions division. But on judicial side, they are all the same. So, they all have same competence of passing sentences, and section 22(2) says that they may pass any sentence authorized by law. So, as we have seen here, authorized by law, we have already seen section 4 BNS 2023 that there would be, these 6 types of sentences that may be passed. However, section 22(2) further says that if these judges pass sentence of capital punishment, then any such capital punishment sentence shall be subject to confirmation by the High Court. So, such sentence of capital punishment which is passed by a sessions judge or additional sessions judges would not be executed till it is confirmed by the respective High Court. And the provisions for confirmation of such sentence of capital punishment has been provided in section 407 to section 412 BNSS 2023. So that was about the High Court which can pass any sentence, Court of Session comprising of these judges again may pass any sentence, but then if it passes capital punishment, it has to be confirmed by High Court under section 407 to 412. Now, if we look at section 23, it mentions about the competence of passing sentence of a court of judicial magistrate first class, court of judicial magistrate. Here also court of judicial magistrate, it is second class. So, section 23(2) says that the court of a magistrate of first class may pass a sentence of imprisonment for a term not exceeding 3 years or fine not exceeding 50,000 rupees or both or of community service. That is, a judicial magistrate first class may send somebody behind bars for up to 3 years or may impose fine up to 50,000 rupees or both, or that it may award somebody to exert himself for community service. Court of Judicial Magistrate of second class, section 23(3) says that it may pass a sentence of imprisonment for a term not exceeding 1 year, fine not exceeding 10,000 rupees, or of both, or of community service. So, judicial magistrate second class would be passing a sentence of imprisonment up to 1 year, fine up to 10,000 rupees, or both, or again the community service idea is there. 23(1) says, gives power which a CJM may pass, sentencing power which a CJM would possess. It says, and as I said earlier, CJM is again a judicial magistrate first class. It is just that he is the senior most of those judicial magistrate first class, that he is appointed as a CJM. Now, for sessions judge and additional sessions judge, the power has been the same. So, on that hierarchy, the power is same. They may pass any sentence. They both can pass any sentence. But at the magistrate level, CJM, despite being judicial magistrate first class, but the CJM, despite, as I said, despite being a judicial magistrate first class, has been given more power than a judicial magistrate first class. So, section 23(1) says that a CJM may pass any sentence except a sentence of death or imprisonment of life or imprisonment for a term exceeding 7 years. So, that means a CJM may grant imprisonment up to 7 years or fine. I mean, here fine would be, the sentence of fine would be unlimited, as in there is no limit to it, or both, or community service also. So, whereas at the level of Court of Session, sessions judge and additional sessions judge have not been differentiated as far as the power of their sentencing is concerned. But at the level of judicial magistrate, 3 levels have been carved out: judicial magistrate second class, judicial magistrate first class, and CJM. As I said, CJM is the senior most among the judicial magistrate first class, but then given additional powers, not only administratively, but also on judicial side. So, whereas judicial magistrate second class would be passing imprisonment up to 1 year, fine up to 10,000 rupees, or both, or community service. Judicial magistrate first class can pass imprisonment up to 3 years, fine up to 50,000 rupees, or fine, or both, or community service. Whereas CJM may pass imprisonment up to 7 years, fine unlimited, or both, or again community service. Now, what community service means is, the explanation to section 23 says, community service shall mean the work that benefits the community, but for which the person doing it shall not be entitled to any remuneration. So, community service would be like taking part in food drives, recycling programs, community gardening, cleanup drives, etc. Now, if we go further, section 24 says that if somebody, so we have seen that there is a punishment in the nature of levying fine on somebody. Now, what if somebody does not pay fine? Section 24 says that if somebody does not pay fine, in default of fine, we may send him to imprisonment for that reason, that he did not pay fine. And the limits have been provided by section 24. It says, the court of a judicial magistrate may award such term of imprisonment in default of payment of fine as is authorized by law. And what has been authorized by law? For that we have to see section 8 BNS 2023. Section 8 clause 3 says that the term for which the court directs the offender to be imprisoned in default of payment of fine shall not exceed 1/4 of the term of imprisonment, which is the maximum fixed for the offence, if the offence is punishable with imprisonment as well as fine. Section 25, which talks about a situation where at one trial somebody has been convicted for several offences. So, such examples may be well thought of, where you'll be ordinarily finding cases where in one trial there would be more than one sections pressed against the accused, and they would all be tried at this single trial. Now, it says, when a person is convicted at one trial of two or more offences, then, and he is convicted, of course, he is convicted, then he may be sentenced for such offences to the several punishments prescribed therefore, which, considering the gravity of offences, may be ordered to run concurrently or consecutively. So, for different sections, different punishments would be, if convicted for different sections, different punishments would be provided, and those punishments may run concurrently, as in simultaneously, or consecutively, as in one after the other. Then it says, if it is a consecutive sentences order, then it shall not be necessary for the court, by reason only of the aggregate punishment for several offences being in excess of the punishment which it is competent to inflict on conviction of a single offence, to send the offence for a trial before a higher court. So, suppose there are 3 sections before a court of judicial magistrates. Judicial magistrate, as we know, may pass sentence up to 3 years. Now, in one section, he passes 6 months. In second section, he passes 3 years full. And in third section, he passes 2 years. Now, aggregate, and if he orders them to run consecutively, then it would be 6, as in 3 plus 2 plus 6 months, as in 5.5 years. Now, it is obvious that judicial magistrate has power to grant sentence only up to 3 years, but effectively it is coming to 5.5 years. Now, section 25(2) says that it will not be necessary for the judicial magistrate to send such case for trial before a higher court. So, that means to say that he would be himself capable of passing this sentence. Then it further says, then it places limit on that. It says that in no case shall such person to be sentenced for a longer period than 14 years. So, this cannot go beyond 14 years. Then it says that the aggregate punishment must not exceed twice of somebody's competence, as in if judicial magistrate can pass up to 3 years, it must not go, if the court is of judicial magistrate, it must not go beyond 6 years, which is not the case present with us. So, and then 25(3) says that for the purpose of appeal, the aggregate of consecutive sentences shall be deemed to be a single sentence for preferring appeal. Now, section 28 then deals with withdrawal of powers. It says High Court or state government may withdraw powers conferred by it on any person. Then, so that was 1. 2 says powers conferred by CJM or DM may be withdrawn by them. Now, we must be noting here that it is only the powers which are conferred by these offices, High Court, state government, CJM, DM, that may be withdrawn. Powers granted by BNSS, say, they cannot be withdrawn by these authorities under section 28. So, it is only the powers which they grant they can withdraw it. Plus that the powers would continue till the person from whom the powers are withdrawn, he is intimated of that, or that withdrawal is published in official gazette. Now, let us look at section 29. It simply says that whenever there is a doubt as to who is successor in chief in office in a particular court, it would be the session judge who would be deciding as to who is the successor in office, and for the magistrates, judicial magistrate, CJM, and for executive magistrate, it would be district magistrate that would be deciding as to who is the successor in office respectively. Now, let us quickly look at chapter 4, which talks about powers of superior officers of police and aid to the magistrate and the police. Aid is public aid. Superior officer means officers higher than SHO rank, generally higher than SHO rank. It says, section 30 says, police officers superior in rank to an officer in charge of a police station, that is an SHO, may exercise same powers throughout the local area to which they are appointed as may be exercised by such officer within the limit of his station. Supreme Court in Nirmal Singh Kahlon, AIR 2009, Supreme Court 984 said that the investigation must be carried out ordinarily by an SHO, but then there are cases where the higher courts, High Court, Supreme Court, and even DG Police has appointed a superior police officer to investigate case irrespective of the limit of his local jurisdiction. It was upheld by the Supreme Court in State of Kerala versus PB Saurabhan, AIR 2016, Supreme Court 1194. Now, let us see public aiding police and magistrate. Section 31 says every person is bound to assist a magistrate or police officer reasonably demanding his aid in preventing the escape of any person, B, in prevention or suspension of breach of peace, C, in prevention of any injury attempted to be committed to any public property. So, if the police officer or magistrate ask the public to cooperate, they must not only cooperate, but must aid such magistrate or police officer. Section 32, again public assistance, when a warrant is to be directed to a person other than a police officer. So, that is also a possibility if we look at Section 74 BNSS, a warrant of arrest may be issued to a person other than a police officer. So, if there is such person, any other person may aid in the execution of such warrant. Next, public to give information. These are some sections, and section 33 says that if a person is aware of the commission or of the intention of any other person to commit such offences, he shall forthwith give information to the nearest magistrate or police officer of such commission or intention. Then section 34 mentions about the villages. It says that every officer employed in connection with the affair of village, every officer employed in connection, and here you will find in explanation, it says officer employed in connection with the affair of village means member of panchayat of the village, including headman, and every officer who is specially appointed to perform any such function connected with the administration of the village. They would be the officer employed in connection with the affair of village, and every person residing in village shall forthwith communicate to the nearest magistrate or the officer in charge of the that is the SHO about these circumstances. So, that was section 34. Thank you.
Hello and welcome to this piece of literary snippet. Perhaps the most popular literary genre after novel is the short story. Sharp, compact narratives whose charm lies not only in what is said but also in what remains unsaid. Today I'll be reading one of the shortest instances of a short story that I have ever encountered, and indeed the very charm of this particular story that I'm going to read out today lies in the way it abruptly ends. It is an ancient tale from Mesopotamia which has been retold by several authors, among whom the name of Somerset Maugham stands out. The adaptation that I'll be reading out is perhaps the closest to the one that Maugham wrote. The story is titled, in all of its adaptations almost, as Appointment in Samarra. Here is the story. A merchant in Baghdad once sent one of his servants to the market. The servant was supposed to buy provisions for the merchant, but when he returned, he came back empty-handed. Indeed, the servant had all gone white, and trembling with fear, he told his master that he had met death in the marketplace. When I entered the market, the servant said to his master, I was jostled by a woman, and when I turned to look at her, I saw that she was death. I am very scared, master, because death looked at me with a threatening gesture. Can you please lend me your horse so that I can fly away from Baghdad to the town of Samarra and thereby escape death? The master, being a good man, gave his servant his best horse and saw him gallop off to Samarra to escape death. Then the master himself went to the marketplace and confronted death. Why did you make a threatening gesture to my servant? Asked the master to death. And death replied, it was not a threatening gesture. Rather, It was a start of surprise. I was astonished to see your servant here today, because this evening I have an appointment with him in Samara. See you in the next episode of Literary Snippet. Hello and welcome to this piece of Literary Snippet. British humour doesn't have a very high standing in the world. When people talk about it, they usually do so with a certain degree of disparagement. Yet all this is, I think, rather unfortunate, because if I read out to you a certain section from Jerome K. Jerome's famous novel Three Men in a Boat, you will realize that not only is British humour genuinely funny, it is probably even better than some of the other samples of humorous writings that you might have read in the recent past. The story that I'm going to read out is told by Jerome, who thinks he is suffering from some kind of a malady. I remember going to the British Museum one day to read up the treatment for some slight ailment of which I had a touch. Hay fever, I fancy it was. I got down the book and read all I came to read, and then, in an unthinking moment, I idly turned the leaves and began to indolently study diseases generally. I forgot which was the first distemper I plunged into, some fearful, devastating scourge, I know. And before I had glanced half down the list of premonitory symptoms, it was borne in upon me that I had fairly got it. I sat for a while, frozen with horror, and then in the listlessness of despair, I again turned over the pages. I came to typhoid fever, read the symptoms, discovered that I had typhoid fever. Must have had it for months without knowing it. Wondered what else I had got. Turned up St. Vitus's dance. Found, as I expected, that I had that too. Began to get interested in my case and determined to sift it to the bottom, and so started alphabetically. Read up ague and learnt that I was sickening from it, and that the acute stage would commence in about another fortnight. Bright's disease, I was relieved to find, I had only in a modified form. And so far as that was concerned, I might live for years. Cholera I had with severe complications, and diphtheria I seem to have been born with. I plodded conscientiously through the 26 letters, and the only malady I could conclude I had not got was housemaid's knee. I felt rather hurt about this at first. It seemed somehow to be a sort of slight. Why hadn't I got housemaid's knee? Why this invidious reservation? After a while, however, less grasping feelings prevailed. I reflected that I had every other known malady in the pharmacology, and I grew less selfish and determined to do without housemaid's knee. Gout, in its most malignant stage, it would appear, had seized me without my being aware of it. And zymosis. I had zymosis evidently from boyhood. There were no more diseases after zymosis, so I concluded there was nothing else the matter with me. I sat and pondered. I thought, what an interesting case I must be from a medical point of view. What an acquisition I should be to a class. Students would have no need to walk the hospitals if they had me. I was a hospital in myself. All they need to do would be to walk round me and after that take the diploma. Then I wondered how long I had to live. I tried to examine myself. I felt my pulse. I could not at first feel any pulse at all. Then all of a sudden it seemed to start off. I pulled out my watch and timed it. I made it 147 to a minute. I tried to feel my heart. I could not feel my heart. It had been beating, but now it had stopped beating. I have since been induced to come to the opinion that it must have been there all the time and must have been beating, but I cannot account for it. I patted myself all over my front, from what I call my waist up to my head, and I went a bit around each side and a little way up the back. But I could not feel or hear anything. I tried to look at my tongue. I stuck it out as far as ever it would go, and I shut one eye and tried to examine it with the other. I could only see the tip, and the only thing that I could gain from that was to feel more certain than before that I had scarlet fever. I had walked into the reading room a happy, healthy man. I crawled out a decrepit wreck. Our friend next visited a doctor, and there he got a prescription which said to eat well, to go for long walks, and not to worry his heads over things he didn't understand. See you in the next episode of Literary Snippets. Hello and welcome to this piece of Literary Snippet. We usually know William Shakespeare as the most revered figure in the history of English literature. But we often tend to forget that he has also been one of the most hated figures in literature. And here I'm not talking only about those boys and girls who have to memorize long sections from Macbeth or King Lear or Julius Caesar before they can go and sit for their school or college exams. But I'm also talking about people who are themselves quite famous authors. Tolstoy, for instance, considered the writings of Shakespeare to be, and I quote, crude, immoral, vulgar, and senseless. George Bernard Shaw absolutely loathed Shakespeare, as he did Homer. But perhaps no other criticism about Shakespeare is more damaging than the one which says that Shakespeare is a marvelous storyteller, provided someone has told him the story earlier. Now, this piece of criticism is particularly damaging because it is true. None of Shakespeare's plays contain any original story whatsoever. They are all written using pre-existing materials, pre-existing stories. Now, does that diminish the stature of Shakespeare as a dramatist? Well, I'll leave that for you to decide. See you in the next episode of Literary Snippets.